And we'll begin with our lecture on employment discrimination. As you saw in the reading, the most important laws dealing with discrimination in the US, it's really Title VII of the Civil Rights Act. So now we've talked about the Civil Rights Act before, the Civil Rights Act of 1964. Included within that are provisions barring or making illegal discrimination in the private workplace. So again, based on the Commerce Clause, the federal government passed the Civil Rights Act, showing that discrimination had negative effects on the U.S. economy across state lines, et cetera. And if you remember at the beginning of the semester, there was that the Heart of Atlanta motel trying to sue to invalidate the Civil Rights Act. That obviously failed. And so we are left and now have a federal law barring discrimination. Here, I've got on this slide the list of protected classes. We're looking at race, color, national origin, religion, gender. Now, we'll also talk about disability and age. I should take age off of this one right here. Actually, I think age is part of the Civil Rights Act, Title VII. But these are the protected classes. If you don't fall within these protected classes, then, well, you don't have any recourse, at least not under the Civil Rights Act. Kind of the key component here is that the employer has to have a minimum of 15 employees. So this does not apply in cases where there's like 6 people creating a tech startup or something. Title VII simply doesn't apply. Now, that doesn't give you a right to discriminate. That's still wrong, but Title VII does not apply to you. State laws may. So look for that. This creates an interesting and easy testing mechanism where I'll give an example of like 7 employers or 14 employees, and then kind of lay it out. The correct answer on that one is going to be Title VII does not apply. All right.
Brother Hales, is there any specific reason why is 15 employees or more?
Yeah, I mean, that's a great question. And the reason was that the stated reason is just when you're starting a business, the legislature just thought maybe we should allow them to discriminate when they're smaller. They don't have the resources to perhaps like make everything equal just yet. Anyway, it's just this idea that you're a new business. Let's give you some time. And I think part of it dealt with, if you're under 15 employees, maybe your business isn't dealing across state lines or something. And so anyway, it was just a small, I don't want to say like concession, but it was just like let's make this only apply to larger-ish businesses. 15 employees is still small, but you get what I'm saying. Okay, so the EEOC, the Equal Employment Opportunity Commission, monitors this. If you have a complaint, before you bring a lawsuit, often you have to file the complaint with the Equal Employment Opportunity Commission. They will investigate. Sometimes they'll work it out for you. Oftentimes they don't. I think they only resolve like 10 to 15% of the complaints that they get. Oftentimes they'll say, there may be discrimination here, but we didn't find it. But you jumped through this hoop. Now you can sue, and they'll give you a right to sue letter, which gives you obviously the right to sue your employer for discrimination based on your classification, one of these protected classes. Now, as we're beginning, I think it's important to talk about this and in general about discrimination. Now, this was more difficult in the prior 8-9 semesters that I've been teaching discrimination. Oftentimes I'd have students say, well, discrimination isn't a problem anymore. Because it's 2020, I think that most students see that there are issues with discrimination still, and it exists beyond just the justice system It exists in the employment arena as well. And anti-discrimination laws are designed to correct those wrongs. Discrimination, there have been economic studies about discrimination and what it costs the US economy on a yearly basis. I mean, this is billions, trillions of dollars in lost revenue, taxes, you name it. That there are some major negative effects as a result of discrimination throughout the world. But in the US, they've put dollar figures on this. And so it exists to stop that. Now, that's difficult. This is extremely difficult. And the other studies, I just reviewed another one that I saw this week that just said humans by their very nature are discriminatory. And we don't even need to talk about discrimination in protected classes yet, but you're all very discriminatory. You're discriminatory in who you're attracted to and who you want to date. And that's good. If some creepy person comes and asks you out, I hope that you're discriminatory in who you date. And so there's discrimination that's socially acceptable. And there's also discrimination that's not. And the overlap isn't necessarily like the bad discrimination is what's unlawful. For example, many of you will get this, all right? We're an online class, but I'm just going to tell you, I'm not 6'4", okay? I'm not the tallest person in the world. And yet studies continually show that the taller you are, the more likely you are to get the job. That puts me at a disadvantage, right? The other one is attractiveness, right? So if I go to apply for a job and as I'm about to go into the interview, I see that the other person interviewing for the job is Brad Pitt and he sits right next to me, I may as well just walk out because I don't care if it's for like a law firm or whatever. Sorry, let me turn my light on again. Brad Pitt's getting the job over me every day. I'm secure enough to admit that Brad Pitt is better looking than me. All right. And so those, I mean, that's all wrong. We shouldn't be hiring people based on their height, their attractiveness, these other kind of physical attributes. And yet the law doesn't protect me. It's the reason that Benedict Cumberbatch loses his argument. If he's fired because he's ugly or not hired because he's ugly, well, that's acceptable discrimination under the law. It doesn't mean it's right. And I want to stress this. When you go to hire people, if you have a supermodel come in and then Brother Hales, I hope that you would hire the best qualified person as opposed to these other attributes. And yet, because of human nature, we're drawn to attractive people, for example, and what we consider attractive, that's shifting and that's hard to like knock down and say what that even means. And yet it persists, but don't do it. Hire people based on who can do the job best and who would help improve your business. That's one of the key takeaways that I want to just leave you with.
How about marriage?
What's that?
How about marriage?
Same thing. Yeah. Like again, you're going to discriminate when you're looking at who to marry. and that is okay. I give you permission to discriminate against creepy people. And so, but I kind of draw the line there, right? If you're discriminating based on protected classes in who you're going to marry, well, that doesn't fall under Title VII because it doesn't deal with employment. But again, I hope that you'll consider these things in your personal life, even if the law doesn't restrict it or bar it. So yeah, anyway, there's another dating lesson for you. I just had to sneak it in.
So, Brother Hales, quick question. It's kind of oddly specific, and probably none of us are ever going to have to deal with it. But like, how does this interact with things like movie and TV castings? Because like Just Mercy wouldn't make nearly as much sense if Chris Pratt played Jamie Foxx's character.
Sure.
And so, how does that fit?
Yeah, so we'll get to that. That's the bona fide occupational exception, and so yeah, you're allowed to discriminate when the color is a vital element of the job description. For example, in acting, we're going to allow that. Yeah, good one. Okay, cool. Let me just make sure. Got everything.
So if you unintentionally hired somebody because they were more attractive than the other person that interviewed, but you did it subconsciously, you just like, you didn't know, they both had pretty good qualifications, but you're like, I'm going to hire this person and I don't really know why because I like them. And then the other person brought a case against you for saying like, I'm not as handsome as the other person that employer hired. Is that going to be thrown out in a court of law because there's like no way to prove it at all?
Yep, that's right. There's no legally recognized claim there. I could have done this for every law firm that I didn't get hired with and said, look, you hired Jamie and obviously she's better looking than me and I'm suing for discrimination, and it would just get dismissed. Now I could make the argument that I wasn't hired because of sex, and I'll get to this in a little bit, but I want to make this very clear right now. Sometimes I'll have white males in my class and they're like, well, this means I'm not going to get a job, and people are going to hire others and not hire white males. And anyway, I read a textbook. It was a business law textbook that said that they classified that as reverse discrimination, that discrimination against whites is reverse discrimination. That is so wrong. And that's wrong under US law, under Supreme Court precedent. If you are ever not hired because you're a white male, then you bring a Title VII action on discrimination. That's a valid claim. You were not hired because of race, color, national origin. And so this applies to everybody. If you're not hired because you're male and they only hire females, bring a lawsuit. Okay, and oftentimes 99%, I'll talk about the 1% of the time that
I have a question.
gets away with it. But yeah, Emma, go ahead.
Okay, and this is just straight up out of curiosity.
Yeah.
Because I noticed that our dear old president seems to hire more white people, especially young blonde women, or but with Caucasian race. Would that technically be a suit to file under discrimination?
So it absolutely could be. And to kind of see how that would play out, let me pull up this screen, because what I'm going to do is just kind of lay out how you bring this lawsuit against somebody. So let's get it. It's this one. Share this. All right. So you're seeing this intentional discrimination slide right now. And this shows you if you are a Hispanic male, for example, that applies for a position, and yet the only people that get hired are attractive blonde females. Well, throw the attractive part out because that doesn't matter under the law, but white females, let's say. Well, it's called disparate treatment. Some people call it intentional discrimination. I prefer disparate treatment, and that's how you pronounce it. Some people say disparate. Anyway, it's disparate treatment. The plaintiff, you as the person that was not hired, to bring this lawsuit is simple. All you have to do is prove these 4 subpoints here. The plaintiff is a member of a protected class, so meaning you were hired because of a protected class, your race, national origin, color. Right? So we'll throw that in there. Or perhaps if you're a male and they only hire females, sex would be included. The plaintiff applied for and was qualified for the job. You were rejected, meaning you didn't get the job, and the employer continued to seek applicants or hired somebody else not in a protected class. In this case, let's say it's a white individual. All right. Once you've done that, you've made your case. That's your entry into the courthouse. You've got your foot in the door. It doesn't mean you win at all. And oftentimes these lose, but it shows that you can at least bring a case for this lawsuit. Now, at that point, the burden of proof switches to the defendant. So if we stick with President Trump here, President Trump is able to, at that point, argue, Judge, I went through all of the qualifications, and the person that I gave the job to had more qualifications than the plaintiff in this case, the person that didn't get the job. And that's easy to do as well, because this to some extent is objective. It's not like we throw all of the numbers, meaning the applicant's qualifications, into a computer and it blindly spits out like who's more qualified. You're allowed to have an objective element here and say, look, I judge these qualifications here that the person that I hired to be more important than these other qualifications that the plaintiff had. And even what's been accepted in these cases is not only just qualifications, but employers have also been able to say, well, Judge, the qualifications were about even, but the person that I hired, I just thought would fit in better into the corporate culture of if we're talking about President Trump, into my administration. And that's been legally accepted. And so winning these cases is extremely difficult because you have to show that what the employer, their reasoning that they gave, like that the person they hired was more qualified or would fit in better, you have to prove that was, let me say it like this. The burden of proof then shifts back to the plaintiff. So now the plaintiff has to prove that everything that the employer defendant just said was pretext, meaning it was made up. It wasn't their legitimate reason. And really, there was a discriminatory intent in everything that the employer just said. It's a back and forth game. And who decides? Well, it's the jury eventually decides who's right here. Remember, these are civil actions. And so the burden of proof here is the preponderance of the evidence, meaning who's more likely to be right, the plaintiff or the defendant. And so that's intentional discrimination, but that lots of people lose those, right? Because the employer can often say something like, well, I just thought this person would fit in better. It had nothing to do with the plaintiff being a member of a protected class. I didn't make this decision based solely on race, national origin, color, sex, religion. It was based on just these other factors that are permitted. And so that's why I hate that it's called unintentional discrimination. That's why I put it in quotes here on the slide that you're seeing. This is disparate impact discrimination. This is where we get into statistics. That's why that statistics class that many of you are required to take here, it's going to come in handy here, because here there may not be any discrimination on the face of the hiring process, meaning like we don't go out and we say we're only going to hire this specific race or this specific color, for example. But you end up hiring an overwhelming majority of that race or color or gender protected class, right? And so this is where stats becomes important. And it kind of goes back to some of those early questions, like are there quotas? Well, there's not. But in the hiring process, for example, if you have 10 Black applicants and 10 white applicants, and 10 white applicants get the job and 0 Black applicants get the job, well, you can always talk about qualifications and all of that. But if there's a discriminatory impact in the qualifications that you set to hire, that's where this legal theory comes into play. So here the example, I switched this in this class. I used to pick on the South a lot, and a lot of that is warranted because a lot of these cases come out of Alabama and Mississippi and Arkansas and Florida and Georgia and South Carolina. But this specific one came out of Alabama. There was a but let's say it's Salt Lake City, all right? So the Salt Lake City Fire Department is hiring. They have 100 white applicants apply, and 50% of them pass this entrance exam, all right? And of course, the police department is going to say this exam is colorblind. It's just, we give it to all applicants. And then you've got 60 minorities that apply. Let's say that there are 60 Black applicants, and only 12 of them pass this exam. Well, you can see we've got the difference here between a 50% pass rate and a 20% pass rate. Oh. I can't get this light to come back on, sorry. It's so dumb. All right. So here we've got an issue. Now, if this entrance exam is legitimate and everything on this exam is required in order to be a firefighter, well, then that's going to be okay. But what they found is when this case got up to the Supreme Court, and what the courts found was that this exam was testing things that had nothing to do with putting out a fire. Like for simplicity's sake or hyperbole's sake, let's just say part of this exam dealt with understanding and interpreting Shakespeare's plays. All right, that's not what really happened, but there was a literature element here that went beyond just simple reading and writing, and let's say it was a Shakespeare exam. And the fire department was like, Your Honor, their argument was, Your Honor, that this is an exam that we give to everybody, and it's necessary to become a firefighter. And the court looks at in this case, the fire department's attorneys, and they're like, what does Shakespeare have to do with putting out a fire? And when they couldn't respond, it was figured out that this was a disparate impact case, that they were putting on bizarre and unrelated requirements to the job applicant pool to weed out minorities that historically didn't have the educational opportunities that the whites had in this specific case, that the white applicants had. And so again, that got thrown out, and their hiring practices were deemed unconstitutional. The plaintiffs received monetary rewards for this, and it led to changes in hiring practices for firefighting, police, and many other departments throughout the country. All right, so again, you can see that there may not be a discriminatory intent. I mean, with this firefighting one, there clearly was, but sometimes that there may not be an intent, and yet the effect is to discriminate against those in protected classes, meaning it may weed out, or I should say, eliminate a large percent of people based on protected classes. So it could be whites, it could be Black applicants, it could be Hispanics, it could be females. Lots of police departments used to have requirements that you be able to carry 100 pounds, and when you applied to work for the police force, you had to be basically a very strong person. Well, that had the effect of eliminating a lot of the female applicants. And the female applicants, when they sued, they said, look, like, how often do the police carry 200 pounds? And the police are like, at a loss on that one. They didn't very often. And they found that they weren't upholding these same requirements as you worked your way through the police force. So you had some 20-year veterans of the police force that were extremely overweight, that couldn't pass these entrance exams anymore. And the courts are like, what are you doing? Like anyway. And so again, and you'll see this when we get to airlines too, that they were doing similar things. So again, disparate impact and disparate treatment are both considered violations of Title VII anti-discrimination laws. Okay.
So, Brother Hales, quick question on disparate impact.
Mm-hmm.
Let's say, kind of like Suits, they only hire out of Harvard.
Yeah.
And Harvard decides, we're going to stick it to whoever we want. We're only going to hire this race, or we're only going to admit Mexicans into Harvard. And so now only Mexicans can get a job at the suits firm because the suits firm only hires out of Harvard. How does that impact the firm? Because their intent is to just hire out of Harvard, not necessarily to discriminate. And Harvard's the one discriminating.
Again, if you can trace it back to discriminatory, maybe not even intent, but effect, like what you just described, those from other national origin, color, and I'm blanking on the other one that I've said 30 times already today, national origin, color, color and race, then yeah, that's going to be deemed discriminatory. Yep.
But do they go after, so they go after Harvard then and not the law firm, or do they go after the law firm?
The law firm.
Okay.
Well, they could
Really?
go to Harvard as well, but within the employment sense, they would go after the law firm.
Gotcha.
All right.
Very
And-
helpful question.
Yeah.
So I have a friend who works on campus, and I won't say which department it was or it is.
Yeah, I'm recording, so good call.
Yeah, yeah. So one of the requirements, because they posted a job and they pay you well in the department, they were like, oh, you have to be like either a native English speaker or like close to native, which is really ambiguous when you say close to native,
Mhm.
because there's no way that they can tell that through a resume, correct? So he used to work for this, and actually this was one of the main reasons why he left. But when they were in the hiring process, he was part of the hiring process, so he was like looking over resumes. He noticed how a lot of international applicants, their resumes just were rejected automatically because they were already automatically thought that they weren't able to uphold to a native speaker level than other Americans or Australians or British or whatever.
Yeah.
So in this case, and I know like there's protections for like whistleblowers and all of that, but when we are in this hiring process and people just don't know, like you weren't selected,
Mhm.
correct? And
Yeah.
it's more like people who work inside who can make the claim or whatever or to what happened. And
Yeah.
in this case, this happened to my friend, and that's why he left the job. But he didn't say much about it. He just like commented to a group of us, friends. What could be a procedure that could be taken, and is this also under the disparate impact discrimination?
Yeah. So what you've laid out is the potential groundwork for a disparate impact case here. And again, you look at the statistics of and it's kind of two-part, right? Because you have one, if you're going to put a requirement that you have to be a native speaker or near native speaker, whatever that means, well, it has to be tied closely to the well, not the qualifications, but the job requirements. Like you have to be able to justify that requirement for the job. Maybe you're dealing with donors and you're on the phone frequently or something like that, I'm guessing.
Like a news anchor?
Yeah, perhaps. Yeah, I think that's exactly right. Like if I applied to be a news anchor in Central America or something, I speak Spanish just not very well anymore, right? And so if they refuse to hire me because of that, they would be well within their rights. You don't want people like watching the news being like, what did Brother Hales just say? And so that could be a justifiable reason for that job requirement for the application process. Now, beyond that, then you get into the statistics. You take the pool of the people that have applied to the job, and if their hiring process pushes out more applicants that qualify under a protected class, then if you get all of that together, in the end, what it means is there could be a disparate impact case under Title VII. So it requires a lot of analysis as well as statistical analysis beyond just the legal issues as well. But yeah, good question. So yeah, that's why I brought it back to this slide. But if we go to this one, I point out because this is important. The law bars discrimination based on religion. So in this case, kind of the most common one that I hear from my students is they say, I went and I applied at Applebee's in Rexburg. I told them that I would like Sundays off, and then they said they wouldn't hire me. Did they discriminate against me based on religion? Well, maybe, probably, but and that deals with in the Church of Jesus Christ of Latter-day Saints, this desire among many to not work on Sunday. Well, that's true. You may have been discriminated against based on religion, but that doesn't mean you win the case. The employers are allowed to show that accommodating the religious practices of in this case let's say that it's you that have applied. Well, if they can show that would cause undue burden on the business operations of the company, then the law says, okay, then you are allowed to discriminate based on religion. And this survives here in Rexburg, especially the Rexburg Applebee's. And that's because, like, I think my brother used to work there. He said something like 80% of the workforce there are active members of the Church of Jesus Christ of Latter-day Saints. And they would all like to get off on Sunday. Well, if the manager allowed that, they would have to shut down on Sunday, and they've got corporate mandated operating hours, and one of those is staying open on Sunday. And so again, in that case, Applebee's is allowed to discriminate based on religious preferences and practices. Okay, what you can't do is not hire those from a specific religion where doing so wouldn't cause an undue hardship. And the undue hardship means like it would cause your business to lose significant amounts of money. And so again, that's kind of the crux of this. So again, on the exam and in other examples, like if there is a Muslim applicant who requests to have certain times during the day that he or she can go pray, well, as long as that's not disruptive, if it's like 5 minutes every 4 hours or something, that's going to be okay. Partly because in the US we require 15-minute breaks every once in a while anyway, and so again, that's if you fire somebody for that, well, that's going to fall afoul of this religious discrimination. So
Rahel,
just look.
Is a cult a religion considering the United States?
Okay, so this gets into an interesting discussion. That there was a case where there was a young man who claimed that his religion was the Jedi religion. Okay, so here's somebody just indicating that he was fired because he practiced Jediism, or whatever that is. And there the court said, look, you're making stuff up, like that's not real. And he even brought evidence saying like, look, there's like 8,000 people in the US that identify with this Jedi religion or whatever. And they said, we have to draw the line somewhere. And so it has to be a legally recognized religion. And it has to be a legitimate practices that aren't just invented, which gets, there's some gray area here, but basically they say as long as it's a legitimate, not even a legitimate religion, but it's your legitimate religious beliefs will protect that. Now there are some issues there as well. A Native American group brought a lawsuit saying that part of their religion was the use of substances that are illegal. This was like 30, I don't even remember how long ago, but they were saying, look, we're being discriminated by the US because it's part of our religious heritage that we smoke this substance, and the US has made that illegal. That's violating our religious beliefs. And they lost that as well, because the government said, look, like the government has the ability to regulate what it considers dangerous substances, and therefore that takes precedence over your religious beliefs. We've seen this too in the church history of the Church of Jesus Christ of Latter-day Saints. There were lawsuits brought saying, look, polygamy is part of our religion, and the government shot that down as well, so saying that the government has a strong incentive to protect families and protect from abuse, and therefore we can legislate and make illegal polygamy. And so again, there's this interplay between different rights and religious freedoms and religious rights versus the national interest in regulating certain substances or practices. Again, for the exam, that can get complicated. Go to law school if you're really interested in that. You'll get it. You'll take this in constitutional law. For our purposes, just know you have to let the employees take a 10-minute break every once in a while, as long as it doesn't cause undue burden. As vague as that word is, it'll be clear on the exam. Okay.
It'll be very clear.
It'll be very clear. All right, so that's religion. Let's see. Next one. Oh, and yeah, we have to talk about gender or sex as it's described in Title VII. Again, you cannot discriminate based on sex. Now, with this one, again, this is what has changed in this year, right? And now sexual identity and orientation are now protected as well, which is that first bullet point. But the second bullet point gets quite interesting. Employers are prohibited from classifying jobs as male or female. And this became an issue largely because of the airline industry in the 60s. If any of us none of us were alive in the 60s, I don't think. But if you went back in time and flew in the 60s, they didn't have flight attendants. They were just known as stewardesses. And maybe your grandparents still call them stewardesses or something. And again, there were requirements. Pan Am was like the airline giant in the world. They had requirements for how tall the women had to be a stewardess, the length of their skirts. All of this was highly regulated, their waist size. And again, when they were sued, because in the 70s, males started applying for these jobs and were denied, the airline's defense was, look, judge, or the 60s when they started getting sued, the airlines, their defense was, look, judge, our clientele, largely male, they don't want to have a guy flight attendant. They want our attractive stewardess. And so, judge, it's just supply and demand. What was their argument here? And they lost. Why? Because being a flight attendant had nothing to do with being male or female. Like being able to bring drinks to somebody. Females just aren't naturally better at bringing drinks to somebody. And this, by the way, when I have my live class, usually there's some like sexist guy in the back, and they're like, yes, there are. And then I smack them around a little bit, because no, the physical activity of bringing a drink to somebody has nothing to do with your sex. And so those laws got struck down. The courts basically said, we don't care what your clientele thinks. They're sexist. So we're trying to get rid of that. So you can't base your hiring practices based on the preferences of your clientele. Now,
How about like the prostitution club though?
Okay, so Chang, let me move this a little bit further, because this is usually where somebody brings up. Like I'll always have somebody raise their hand in class and they're like, Brother Hales, you're wrong. Hooters still exists. Okay, so now we have to talk about Hooters. All right, and what is the difference between Hooters and Pan Am Airlines only wanting to hire attractive females on their flights versus Hooters wanting to hire attractive females to bring you wings or something?
Isn't Hooters going bankrupt?
Yes. So Emma's absolutely right. Like this business model is going under, but they're going bankrupt because like who wants to admit to going to Hooters? Like nobody. It's almost as bad as McDonald's. I'm
Their
not
wings
going.
aren't even good.
Yeah. So this is exactly right. And Hooters has been sued time and time again over the same thing, and they keep winning these cases because they say, look, Judge, unlike Pan Am, where the job description is just to bring drinks and peanuts to people, our business model is built around having attractive females bring drinks to people. It's not what the clientele necessarily wants. It's just, and basically the way that they did it is they classified it as an entertainment industry where you're allowed to use the bona fide occupational classifications and basically say, look, we've built a persona. Our entertainment, for example, is built around this. It's the bona fide exception, by the way, is the same reason that Disney doesn't have to hire males to dress up as Cinderella and pose as Cinderella taking pictures with the little kids. Gender is an integral part of Cinderella's persona, and so that's why they're allowed to discriminate based on gender there. It's because of that bona fide occupational exception, and it's limited. And like I said, Hooters has used this successfully. They're just going out of business anyway. So that's what's going on there. All right, it is 11:30. So feel free to jump out. I'm just going to keep recording and I'll upload this for you all later. And when you watch it at 2 times speed because I talk so slow and I'm sorry for being Californian. All right. Now, this last bullet point I think is important, wage discrimination. Sometimes my students, that they talk about this like, oh, Brother Hales, did you see that Iceland just passed a law that in Iceland you have to pay men and women the same? And I'm like, yeah, they copied it from us in 1963. That's how long this has been on the books in the United States. And I thought, in previous semesters, I mistakenly said that the US was the first to introduce this fair wage law. I was wrong. France passed it first. So right after World War II, France passed the very first equal pay law. The US was after that in the 60s. And what that says is that men and women doing equal work have to get paid the same. Now, this can take into account the amount of time that you have been working at the place of employment. And so anytime that you see these statistics saying that men make more than women for the same job, well, oftentimes they're not adjusting for the amount of time that the male has been at this place of employment and so that accounts for much of the difference between men and women's pay. But it actually doesn't, like other studies have shown, that it doesn't adjust for, or it doesn't account for all of the difference. And so there is still discrimination. And if a female is being paid less than a male, adjusted for the time there and the amount of work and the job description, then then you can bring a lawsuit for that. And females have been successful with these cases, largely, I think, since the 80s. That they've been successful in proving the civil claim for unequal pay. Okay, so that's important just because that comes up a lot, quite a bit as well. All right, so here, constructive discharge just means you weren't fired, but you might as well have been fired. Why? Because the employer made your life so miserable as a result of discrimination based on your protected class that a reasonable person would have left, would feel compelled to leave the job because of how horrible it was. Largely, this is built off of the hostile work environment, which we'll get to on Friday. But my first real life experience with this came when I was a corporate attorney for a business in Florida. They had an out-of-state office who we're going to call her Kate. She was the only female on the sales floor of this company. So imagine Kate and like 12 other males. And while she was there, the sales floor had always played with Nerf guns, and this was a call-in center. So when they weren't taking calls, they'd get off and they'd shoot each other with these Nerf guns. Well, when Kate came, it kind of changed the dynamic a little bit, and they decided it would be fun to start targeting Kate. So, it was actually a terrible situation. If they hit Kate in her rear end, you would get something like 20 points. If you hit her in the chest, it was 30 points. And they had started like targeting parts of her body and assigning different points to it, right? So Kate would go home. She complained to HR. HR didn't really do anything. She would go home. She would cry. She started having to see a therapist. It just made working extremely difficult, eventually to the point that she did quit. And so when she brought the lawsuit, this file got thrown on my desk. I read everything that was going on, called up her attorney, and we just immediately started talking settlement numbers because this was a perfect example of constructive discharge in a hostile work environment. And so again, we settled this, and Kate went on her way. She didn't even want to come back to work, which I didn't blame her. We just paid her to make up for lost wages, pain and suffering, and let her move on with her life, and then start making changes in the company itself. All right, age discrimination. I love talking about this because you'll all get to deal with it someday, and some of us sooner than others. I like this one because I'm still in my 30s, but I'm getting closer to 40. So this one, and it's interesting because I still feel so young and hip. And when I do stuff like this, it makes me feel not young and hip, but I still feel young. And yet, once you are 40 years old or older, you can sue for age discrimination. And so again, making out this claim is relatively simple. You just have to prove that you're a member of the protected group, 40 or older, you were qualified, and you were fired or didn't get the job because of age discrimination. Again, the employer has the same defenses. Yeah, we looked at Brother Hales's application, but when we saw Jeremiah and that he was young, oh, just kidding. You don't say that. You just say Jeremiah had the same qualifications and we thought he'd be a better fit. Then my claim gets thrown out and I lose. But again, you can use statistics for this, just like with Title VII discrimination. Age discrimination will follow the same path.
But even older people normally have more experience.
Yep. Yeah. So it has to be usually what they'll say. I've actually seen cases where the employer says something like, well, we wanted to hire Jeremiah because he had more vitality, which is just code for Brother Hales is super decrepit. Right. And those have been accepted that's okay. Like if the person is more active and engaged, then you can get around the age discrimination. Now, again, I'm going to say these are code words for discriminatory intent, and you can win those. Just like women have often won cases based on these, what we call code words. They'll say something, for example, when a female is fired, the HR report sometimes, hopefully not in your case ever, but it'll say something like, yeah, well, Jessica was very moody. And they found that like words like moody, easily upset, that these are more associated with female workers than with males. And so they found discriminatory intent based on these basically what have now become discriminatory words. So again, it's just something to look out for. All right, ADA. So now we get into discrimination. This isn't part of Title VII. The ADA is its own rule, but tracks a lot of the Title VII foundational rules. So again, with ADA, just remember it also applies to 15 or more employees, meaning you can discriminate based on disability if you have 10 employees. You shouldn't, that's wrong. But the ADA doesn't come into play unless the employer has that many workers, like the minimum amount. And basically what this says is make reasonable accommodations for your employees that are disabled. If you've got an employee in a wheelchair, get a ramp. Again, you've got some of the same defenses as before, like if it would cause an undue hardship, like with the religious discrimination, then you don't have to build a ramp and you don't have to hire that person. But if you're Apple and somebody asks for a ramp or a specific type of, like I work with people here with other professors, they tend to be older than me, but some of them have back problems and that could be tied to disabilities, and they get super cool like $1,000 chairs that are super comfy, and I get this piece of garbage that is like not comfortable, but the school doesn't care for me. Well, they would if I brought it up, but they're like, you're in your 30s. And so deal with the crappy chair, Brother Hales. And I'm like, whatever, cool. Like when I'm older, I know that the school will accommodate me with a better chair that's more comfortable. But right now I just deal with the leftover junk that they had and they just threw in my office. So again, whatever. But that's really all that you need to know under the ADA beyond what's in the reading. All right. And then defenses, we've largely covered these. Yeah, did I hear a question?
I have a question on the disabilities portion. So what if, let's say, one of the professors at BYU gets in a horrible car accident. They recover almost all the way, but something interferes with their speech now, and so, like cognitively, mentally, they're still the same individual. They're still there. They just can't articulate anymore. And I know being able to articulate is a huge part of a teacher's job. I mean, you have to be able to teach your students. How would BYUI be able to accommodate that? Like, because I mean, they wouldn't be able to give lectures, but they can still write curriculum and whatnot.
Yeah, and working for BYU Idaho, I know that they would work to find something, right? Like it's a great place to work in that regard. But oftentimes if you're a public speaker, which is what a lot of being a professor is at BYU Idaho, we don't do a lot of research like my fellow professors at BYU do. They'll teach one class a semester and spend the rest of their week or semester researching and publishing. And I don't have to do that, but I'll teach 3 or 4 classes a semester. And if I can't speak, well, that's going to be like on this slide right here, that may be a business necessity, is having that ability to speak and lecture. And if I lose that, can I really do the required functions, the requirements of my job? And if I can't, then legally I can be fired. So yeah, to answer your question, if you lose the ability to do the fundamental job requirements, and there's no way to remedy that, there's no amount of accommodation that's going to get you to those minimum requirements on the job, then you can be let go. And these are the defenses that employers use: the business necessity and the bona fide occupational qualification. Yeah, and on this slide,
Brother House,
yeah. Let's take a question.
is there any organization that regulates like employers and the salaries that employees receive. Because, for example, I'm taking right now my class of race and ethnic relations, and I'm doing my research paper about the difference between the salaries between white people and African Americans, and Latin Americans. And basically, African Americans, their salaries, even they have the same position than a white person, are still like 60% of a white person. And I think Latinos were like around 75%.
Mhm.
So how, because like when you're an employee, you don't know like others employees salaries. Like that's not something that you really talk about unless that you're really really familiar with the person. But
Yeah.
even like that, you don't really comment your salaries. Is there an organization that kind of like restricts this employee discrimination based on race to the salaries that they receive?
Yeah, so great question, because most well, maybe not anymore, but it used to be fairly common that when you took a position as part of your employment contract, there was a non-disclosure clause in there saying that you wouldn't disclose to anybody how much money you make. That has been found to perpetuate racial disparities in salaries, just like you're saying. And so a lot of those, well, I should say many states, not Idaho, surprise, but California and other more liberal states are eliminating those non-disclosure clauses and saying that that's unconstitutional in an effort to normalize salaries among not only men and women, um, but across race as well. And so yeah, that's I think in other states you'll see that push so that you can get more information about how much you're getting paid in comparison to others within your organization with the same skill, education, experience, time at the company, all of that. And the idea is to normalize the pay rate among um, different groups of individuals. Yeah, because right now getting that information is extremely difficult. Now you've got like anonymous websites where you can put that information and they will do this for you. But I think that there's going to be, if not already in the state, I think at the federal level, there will be a push to publish this information and make it more readily available. Yeah, good question.
So
All right.
in line with that, how does that work for things like commission? So like let's say I work at a sales floor, and maybe I'm not the best salesman. You know, like I'm good at my job enough to keep making a living, and I have a friend who's whatever different race you want him to be, but they're a minority race. And some guy comes into the sales floor. I'm making a sale. My friend who's a different race, he's a better salesman than I, so he makes more commission. And the guy just assumes that our company is racist and says, thanks. Now I'm going to go close this with him so that he gets the commission because you're probably getting paid more because you're white. Like, how would that, because that's not on the company, that's on the customer. So like, how would that?
Yeah. Basically, and that probably falls outside the scope of this class, like because you're getting to like real discrimination on the part of consumers, and we're talking about regulating discrimination in the workplace. And the truth is, we can't. It's hard for the law to root out discrimination on the part of consumers. And what you described was racist, and that's something that's why I think we just all need to work together on that, get word out, educate people about discrimination there. But as far as the employer's responsibilities, that falls outside of that, and commission based things, that's going to fall outside of this as well. What the law is trying to do under Title VII is just eliminate wrongful discrimination in the workplace. Again, what it considers wrongful discrimination. And it doesn't ban all discrimination. Like I said, you are legally allowed to discriminate against people that aren't good looking or just average looking. Like, and for all of us in the class, by the way, that are average looking, it just means we have to work harder, because there's no justice for us yet. But in your own personal life, and yeah, Dan, I think this is a great question, because I think it's a great way to end the class. The law can't fix everything. It requires all of us to work together to try to identify and root out our discriminatory practices in all aspects of our life. It could be in our religious beliefs. It could be in the way that we interact with others on the street, in the store, etc. But as we do that, then we move towards being a more fair society. And that's what this is all about anyway, is the desire to have, in the United States and across the world, but these are US laws, a society where everybody can succeed regardless of their race, color, national origin, gender, disability, age. We want to cover all of that, religious beliefs. And so that's my challenge to all of us, is to work towards doing just that. And I have a lot of faith that we can, despite our current challenges. So, all right, let me stop.